Hello everyone, welcome to Lecture 5 on Loss and Notice of Loss of the Insurance Law Lecture Series. Loss in insurance means the injury or damage sustained by the insured in consequence of the happening of one or more of the accidents or misfortunes against which the insurer, in consideration of the premium, has undertaken to indemnify the insured. In property insurance, loss means the pecuniary detriment consisting of the total cash value of the property in case of total loss, or the reduction of the value thereof in case of partial loss. In life insurance, loss occurs when the person insured dies, while in health insurance, loss occurs in case of injury to or disability of the insured. In both cases, the loss must have been caused by the peril insured against or is otherwise covered by the policy. Proximate cause is that cause which, in natural and continuous sequence, unbroken by any efficient intervening cause, produces the injury, and without which the result would not have occurred. While remote cause is that cause which some independent force merely took advantage of to accomplish something which is not the natural effect thereof. The insurer will not be liable if the peril insured against is a mere remote cause. In tort cases, the defendant is not liable if his negligent act is not the proximate cause of the loss, while in insurance cases, it would be possible for the insured to recover even if the peril insured against is just an immediate cause and another cause is the proximate cause. Let's take note of the following rules. The insurer is liable if the peril insured against is the proximate cause of the loss. The liability is present even if it is accompanied by a remote cause or an immediate cause, and whether or not such causes are exempted perils. The insurer is not liable if the peril insured against is the remote cause. The insurer is liable if the thing insured is damaged because it was being rescued from the peril insured against. The insurer is liable for damages caused by a peril not insured against to which the thing was exposed while the same was being rescued from a peril insured against. The insurer is liable if the peril insured against is the immediate cause of the loss, if the proximate cause is not an accepted peril. The insurer is not liable if the peril insured against is the immediate cause, but the proximate cause is an accepted peril. For example, in a case wherein the proximate cause is fire and the immediate cause is explosion, the insurer will be liable if fire is a peril insured against, even if explosion is an accepted peril. If fire is an accepted peril and explosion is the one insured against, the insurer will not be liable. Take note also that an insurer is not liable for a loss caused by the willful act or through the connivance of the insured, but he is not exonerated by the negligence of the insured or of the insurance agents or others. Distinction should, however, be made between ordinary negligence and gross negligence. While mistake and negligence of the insured or his agents constitute part of the perils that the insurer is obliged to incur, such negligence or recklessness must not be of such gross character as to amount to misconduct or wrongful acts. Otherwise, such negligence shall release the insurer from liability under the insurance contract. The parties may agree on a stipulation in the policy that notice should be given within a certain period from the time of the loss. The parties may agree that the absence of notice within the period agreed upon will extinguish the loss. The notice is separate from the claim itself, although a claim within the period of giving notice is already deemed compliant with the requirement. However, with respect to fire insurance, notice of loss is mandatory under Section 90 of the Insurance Code. Notice may be given either by the insured or the person entitled to the benefit of the insurance. For example, the mortgagee, who is the beneficiary, may also give notice of loss. The notice under Section 90 should be given without unnecessary delay. It would depend on the circumstances if there was unnecessary delay in giving the notice of loss. For example, there could be no undue delay if the absence of immediate notice was because the insured was injured and hospitalized for a long period of time. The High Court ruled that notice to the agent of the insurer binds the insurer. Under the doctrine of representation, notice to the agent is notice to the principal. As to proof of loss, the law does not require preponderance of evidence because the insured is not bound to submit preliminary proof that is required by regular courts. Substantial evidence is also not required because such evidence is required only in quasi-judicial cases, including cases before the Insurance Commission. All that the law requires is for the insured to give the best evidence which he has in his power to submit at that time. If the policy is valued, the valuation fixed in the fire insurance policy is conclusive in case of total loss. If the policy is an open policy, the valuation is not conclusive, and the loss and its amount may be determined on the basis of such proof as may be offered by the insured, which need not be of such persuasiveness as is required in judicial proceedings. All defects in a notice of loss or in a preliminary proof thereof, which the insured might remedy, and which the insurer omits to specify to him without unnecessary delay as grounds of objection, are deemed waived. Delay in the presentation to an insurer of notice or proof of loss is waived if caused by any act of the insurer or if he omits to take objection promptly and specifically upon that ground. Thus, there are three cases when delay is excused. First, when delay is attributable to the insurer. Second, when there was no prompt objection by the insurer. And lastly, there was an objection, but not specifically on the ground that there was delay of notice or proof of loss. So that's it for today's lecture. Thank you so much for listening.